Okay, folks, we'll call this meeting to order. I'm glad to see so many faces here today. Glad to see this kind of interest in what we're doing. I'm Randy Moore. I'm the president of the board of directors, and I think probably we should start out with going right down the line here and having everybody introduce themselves, who they are and their position. So if you want to start at the end.
I'm Sherry Prue, and I'm trustee.
Ed Pizarski, secretary.
I'm Mike Munson, assistant
Vice President.
vice president.
My name is Matt Heron. I'm an attorney. I'll be talking a lot today.
And I'm Joanne Nink. I'm the treasurer.
And I think most of you know Tammy and Jenny over at the desk over there. I would like to start out by thanking the people that are responsible for this. This has been an ongoing process for about 2 years that we've been working on this. There has been a tremendous amount of hours, some pretty heated discussions that we've had trying to get this right, and it's evolved into something that I think is a much better, more efficient document than we had before. Just as you can see, some of you have probably seen this, maybe a few of you have even read it. These are the old bylaws that we had. These are the new bylaws that we're proposing. You can see they've been much condensed, much smaller, easier to read, more homeowner friendly. There was a tremendous need to have our bylaws updated from a number of different aspects. From a legal standpoint, they were frankly, in some cases, just flat out illegal. Technology has changed that our bylaws did not keep up with. For example, satellite dishes. When the Villages was first formed, they had these enormous satellite dishes that were 10 feet big. Well, they weren't allowed because they were so huge. Now they've got the small satellite dishes. They're commonplace. You see them everywhere. They're not a problem. So it's that kind of thing that we've had to address. Solar panels didn't exist when our original bylaws were written. Something as silly as drones, you know, the Air Force had drones and that was it. Now you can go to Walmart's and buy a drone for $30. So all of these things needed to be addressed. They weren't addressed in our existing bylaws, so we've attempted to update these and bring us into the current status that we have today. So we're going to go over some of the highlights of the changes that are made. For the most part, the average homeowner won't notice a change at all in the bylaws. One of the big things we did was the original bylaws were written by Aspen Management for Aspen Management. So they were geared towards them to sell the units when the Villages was first formed. They're long gone, okay? Yet they still had a lot of rights in here. We've eliminated all references to Aspen Management, okay? The bylaws as they were written gave them a lot of different rights that specifically pertain to them. And they're gone, except for one reference, which is in a historical contents, saying that they were the ones that were responsible for the development in here. It's the only time they're referenced anymore. All the others are gone. Another big change we made, and this will affect a few people, is we've made a change to the rental policy. The one question that the board has been asked, probably more than all others combined, are what are you going to do about the rentals? What we have proposed is you find rentals in every community, every city. They're just a fact of life, okay? We wanted to be fair to the landlords that own these properties. We didn't want to see anybody lose a property. So what we have proposed to do is to put a cap on the number of rentals that are allowed in the Villages of Oscoda. That cap would be at 25%. No more than 25% of the housing in the Villages would be allowed to be used for rentals. We're currently at about 23%. we're about 15 units short of that 25%. Now, we have heard from two very reliable sources that an investor wants to purchase 50 units in the villages of Oscoda. That would be devastating for us in a number of ways, because number one, all of our insurance, homeowners insurances on our houses would go up, because the insurance companies would view this as a rental community, not a homeowners community. The premiums are higher for a rental community. Secondly, if you went to sell your house when somebody wanted to buy it with a mortgage, that buyer would pay a higher interest rate to get a mortgage in here if we exceed that 25%. So some bad things happen if we kind of leave it the way it is, where anything goes. So we put a cap of 25%, no more than 25% on the rentals. We also included a hardship clause. If we were at that 25% and you got sick and you had to move downstate for doctor reasons, medical reasons, whatever, we don't want to see anybody lose their house. That's the furthest thing. So even if we were at that 25%, there would be a hardship clause that we could issue a waiver to allow that homeowner to rent their house so that they wouldn't have to just lose it because they couldn't afford to let an empty house sit. So we've had a lot of very heated discussions about this. It was kicked around every way you can imagine, and we feel this is the most fair and just way, not only to the homeowners, but to the land. We've tried to clarify things, we've tried to make them simpler. In the old bylaws, there was even contradictory statements. On page 13, it would tell you one thing, and on page 28, it would tell you something totally different. You know, that's the way Aspen wrote these. At the time, I guess it was acceptable, and again, they wrote them for themselves for their own benefit. Well, we have since evolved from a development company trying to sell these units into a homeowners association, which is what we are today. And the old bylaws just didn't reflect that. So that's why we've done what we've done, taken 2 years to do it. You know, some other little minor things, as I look out into the parking lot, according to the old bylaws, just about every car is eligible to get a violation here. Because the old bylaws say you can't have a vehicle weighing over 2,500 pounds. How ridiculous is that? So you can all pick up your violation letter on your way out today. But, you know, the intent when Aspen wrote that was they didn't want your neighbor who happens to be an over-the-road semi-truck driver parking his big rig out in front of your house and letting the air conditioner, the refrigerator run all weekend long. That's what they meant, but that's not what they said. So we've refined things like that to make it more reasonable, easier to understand, that type of thing. So we're faced with a law that is from the Michigan Condo Act that says we have to have a 66 2/3% approval from the homeowners for this to pass. The problem we have is if somebody does not return a ballot, it's counted as a no vote. It's not our rules. That's the Michigan Condo Act. They intentionally made this very difficult to amend or change bylaws because they don't want rogue boards going nuts every year changing the rules and being impossible to comply with. So by design, it's a very high bar that we have to clear. So every vote is important. We've done everything we can possibly do. You've probably noticed the little, I call them political signs that have been posted on Bissonnet and Mission. We've got banners on both entrance signs. We've had it in the newsletter. Our electronic sign out here has please vote on it. You know, everything that we can do, we've tried to do. So it's now in the homeowner's hands. You let us know if this is something you want or you don't. But I would at least ask you to please return your votes. You have until the annual meeting, July 20th, to turn your ballot in. And if you're unsure Something we've done this year that we've never done before with these ballots is we have included a proxy vote. This can be kind of dry reading. We get that. We understand that. Not everybody's going to be able to get through it. If you're not sure, you can use the proxy designation in your ballot and assign your vote to a board member to vote on your behalf.
Or anybody else.
Or anybody else, yeah. You can designate anyone that you want, your neighbor, anyone. You can designate your proxy vote to. But I can't stress enough that it's very, very critical that everybody return a vote. If you're against it, well, vote that way. Don't just ignore it, because that doesn't give us a gauge of where we're at on this. If you have a question, an issue, a problem, and you say, well, I agree with everything except this one part, we can maybe address that. We'll see what it is, and if it's something that can be changed, we'll do our best. But please, please return your ballots. Talk to your neighbors, let them know how critical it is. Again, I'm encouraged to see this many people here today. I think this is probably one of the largest crowds we've had since I've been on the board, and I'm glad to see it. So what we're going to do is we've done a roll call, we've done our introductions.
That's the board.
Do we have our two candidates that are running for the, okay, if you would like to stand and introduce yourselves.
No, we're not the candidates.
Oh. Are they here?
One of them is. Have them stand. Have them stand.
Okay, if you would like to stand and just introduce yourself. The ballot for the elections will also be contained within that same packet that you either pick up or receive in the mail.
My name is Christian Galdoni, my wife Corey.
Where's the mic? Sorry, the mic.
My name is Christian Galdoni. I'm here with my wife Corey. We live in the area. We do own some rental properties here on base within the Homeowner Association. And we've been living here about 2.5 years now? About 2.5 years. We've been affiliated with the area for closer to about 6-7 years, and we're happy to be around here.
How many properties do you own?
3.
Did you ever live on the property here?
No. We live up in Greenbush.
Is our other candidate here?
I think she's right back there.
Okay, if you'd like to step up to the mic.
Hi, I'm Bev Knickerbocker. Did everybody hear me?
Yep.
I also have been here about 2 years as of Memorial Weekend, and as of today, I'm going to be working in one of the Oscoda shops, Scents and Accents, trying to get that going. I think the fact that you have somebody wanting to buy 50 units in here tells you that Oscoda is ready to go up. And I'm looking for, the place to get moving to in the right directions and fill some of these empty buildings downtown.
Okay.
So that's what I'm doing, and that's why I'm here. If anybody has any questions.
Okay, we're
I live on Alaska Street. Yeah.
gonna save any questions until the very end. So if
All right.
anybody has any questions, we'll let you know. Okay. Next on our agenda, we're going to hear from our attorney, Matt Herron. Everything that we did as far as the bylaw changes, the bylaw committee reviewed them. They went to the board for our approval. Then they went to Matt to make sure that they were all legal and were workable. So we're going to hear from Matt now.
Hello, good morning, everybody. My name is Matt Herron. I know that many of you probably just either this week or recently received the package of materials that you're being asked to vote on. It's pretty lengthy, so I understand that very few, if any of you, have been able to read the entirety of it. The purpose for me to be here is to give you sort of a roadmap or an explanation of what you have and the significance of it. The voting period, as Randy indicated, doesn't close until July 20th, So the goal is to provide you with the documents, give you an explanation of the documents, the basis for the change, and the processes for the amendments, and allow you to draw your conclusions as to how you want to vote, so you can go into July 20th with making an informed decision. Part of what I wanted to do was describe, kind of the ship, how this entity functions and how it operates. There are several different governing documents that monitor, regulate, and govern how a condominium and the homeowner association or condominium association that administers it operate. You're only being asked to vote on 3 of those, and there's 5 of them basically altogether. The homeowners association is a corporation like any other corporation. It's a nonprofit, but like a McDonald's or like Ford, it's still a corporation, and the co-owners are its members. So by virtue of owning a unit here, you are a member of a corporation, and that corporation must be registered with the state and recognized by the state and have annual reports. It also must have a board of directors, which is who you see up here, and then it will have officers that are appointed by the board of directors. One of the things that we are doing is we are updating the Articles of Incorporation. The Articles of Incorporation are that document, or is that document that is filed with the state of Michigan that in essence registers this entity, the association, as a valid nonprofit corporation. This corporation was initially adopted back in 1998, and so the amendments, the amended and restated Articles of Incorporation intend to update those articles to reflect some changes in the law that have taken place between 1998 and now. So one of the documents that will be in your packet, you'll see it's called an amended and restated Articles of Incorporation. It's among the shorter, I think it's maybe between 6 and 10 pages. So you know the voting process. You have 2 ballots that you would have received. Only one of those ballots pertains to the amendment process that I'm working on. The other ballot deals with the election of directors, which is part of what the 2 candidates were here. So everything that I'm talking about deals with the ballot on the request to amend the amended and restated Articles of Incorporation and the Master Deed and Bylaws. As Randy had indicated, the Master Deed and Bylaws have a 2/3 vote, but the Articles of Incorporation have a lesser standard. They have a majority vote. At the time that you purchased, you probably received the big packet that Randy demonstrated. That big packet's going to have that master deed, which is the developer saying, I basically create this thing, the bylaws, which would be Exhibit A to that, and then behind that, because this project is very large, you'll have dozens and dozens of pages of architectural plans. Those architectural plans describe the layout of what Villages of Oscoda is. Separations between units and general common elements, where the roads are, that kind of thing. Nothing that we are doing is changing anything in those architectural or engineering plans. Nothing that we're trying to do will change that or affect what's called that subdivision plan. The configuration and layout, the thing that is Villages of Oscoda, will not be changing. What is being proposed to be amended is the master deed and the bylaws. The way that I describe the master deed and bylaws are that the master deed basically describes the relationship between that entity, the condominium, the Villages of Oscoda condominium, and the land itself. So it will describe the relationship between what you buy as a unit. When you buy the unit, and then you have an exclusive right to use something that are called limited common elements, and then everybody has a right, subject to the documents, to use what's called general common elements. That master deed describes the relationship between those things, and then it also describes something called percentage of value, which is something that is pretty significant for each individual owner. We are not changing anything that you own. We're not changing your right to use your limited common elements. Those are yours. Those are yours. Actually, I could have watered.
Thank you.
Nor are we changing your percentage of value. Those are already set. Those exist, and we couldn't change those without your permission anyways, so those things are not going to change. The bylaws are really comprised of 2 different things that somewhat work together. If the master deed describes, in essence, the relationship between the condominium and the land, The condominium bylaws, in essence, describe the relationship between a co-owner member and the condominium itself. One of the most significant provisions that you will most likely want to review is Article 6 of the bylaws. As Randy indicated, there are certain restrictions that are set out in the amended and restated bylaws. There are also restrictions that are in the old bylaws also. And one thing that you could do is to compare the two to see if you're interested in seeing the differences between them. But the bylaws themselves, the portion of it that's generally referred to as the condominium bylaws, describes those things that you as a co-owner need to do or cannot do vis-a-vis the land and vis-a-vis the condominium. It deals with things such as insurance, the payment of assessments, the vehicles, rentals, pets. There is an architectural control committee here in Villages of Oscoda, so what you can do with respect to the exterior of the home, those things are set out in your condominium bylaws. The second part of the bylaws are what's referred to as the association bylaws. The association bylaws describe, similar to the Articles of Incorporation, but slightly different, what can be done here. This is an informational meeting, but what you can do at meetings, whether it's a co-owner meeting or a board meeting or the election of directors. But the association bylaws describes the process of how the company is to operate, kind of like how you're going to operate in the captain's ship of the captain's room of the ship, I guess. But it describes how the association functions among itself. The number of directors, when directors become elected. Under the new bylaws, you'll have 5 directors elected in staggered sequence, so 3 one year, 2 the next year, with the goal being that you have a transition and you have individuals with institutional knowledge that will be able to carry over. Also quorum. Quorum is one of those components that's in the association bylaws. That is the master deed, the condominium bylaws, which include the association bylaws. Those things are what are being proposed to you and what you are being asked to vote on. As Randy indicating, the voting process is a 2/3 vote requirement. There's a slightly different, it's kind of unique in a certain sense, but basically anybody who is capable and qualified to vote as of the day that this package was mailed out counts for purposes of that 2/3 vote. And it is a 2/3, absolute 2/3, so you need to get 2/3 of everybody to respond, and a non-response is it would be considered a no. As the process goes, July 20th will be the end of the voting period once the annual meeting is over. If the voting process passes, hypothetically, let's assume that it goes through and that a 2/3 vote is achieved. That doesn't quite conclude the process. What you most likely received in your packet that some people, and I hear this all the time, and it's totally understandable, you would have received a mortgagee form. And you may be looking at it and saying, why the heck did I receive this mortgagee form? It's none of your business what the balance is of my mortgage. It's none of your business what my mortgage company is or whether I have a mortgage or not. Well, under the Condominium Act, what the Board of Directors is required to do is if it passes the co-owner vote, every mortgage company that has recorded a mortgage against a unit here, a first lien mortgage, also has the right to vote, because they lent money to people based upon an expectation of what their rights were. And if the amended and restated bylaws trigger certain components, then they have a right to vote on it. One of those is leasing. So if there is a change in leasing, then mortgage companies get an opportunity to weigh in on it. The voting process with respect to a mortgagee is the same, but also the opposite, if you can understand that, of the co-owner voting process. What would happen is, let's assume that July 20th it passes. Shortly thereafter, much like all of you received, there would be a voting package that goes out to each first lien mortgagee. And each first lien mortgagee would have the right to vote as many number of units as they have mortgages against it. So let's say PNC has mortgages against 30 units, they'd get 30 votes. That's how that process would work. Much like the co-owner vote, the mortgagee vote also has to pass by a 2/3 vote majority. So 2/3 of all mortgagees, counted by the number of units against which their mortgages, are required to say yes in order for the vote to pass. As to the master deed and bylaws, mortgagees are not entitled to vote on the articles of incorporation. However, the opposite part of it is that, and this doesn't happen all that often, but in the legislature's infinite wisdom, they recognize that mortgagee companies may be slow to do things. They may not exactly respond in a timely fashion. And so they said, fine, you can do that. We're going to give you a time period within which you have to vote, and they get 90 days. So there's a 90-day window where a mortgagee company has to return their vote. Unlike a co-owner vote, which must be a yes in order to be counted, a mortgagee must vote no in order for its vote to count as a no. If a mortgage company does not respond, that counts as a yes vote. They have the opportunity, and that's the chance for them to respond. The difficulty with that is, were it to be the other way, then nothing would ever pass. We've done dozens of these, and we get 3 or 4 mortgagee votes for an entire process. You guys are pretty large. I mean, you're almost 800 units, so you'll probably have more mortgagee votes come back. But the way it works is that they'll get the opportunity, 90 days. If less than, it ends up being that if less than 1/3 of no votes come back, then it would pass that mortgagee vote process. But that does end up being a 90-day window of time. So with respect to expectations of a time period and when you can expect this process to conclude, if it does pass at the co-owner vote stage, which would close on July 20th, then as a practical matter, you're looking to the end of October, beginning of November, as when you would next know how the vote went. And so, just so you know, from a timing perspective, this process, which did begin a couple years ago, it will not and cannot conclude if it's going to carry forward until towards the end of this particular year. There's one other set of documents that you're not actually being asked to vote on, but I wanted to let you know about, and so you know they exist, so you can separate them from what you are being asked to vote on. One of the aspects and tasks of a board of directors is to administer the documents and administer the condominium, and that involves enforcing the bylaws. It involves collecting assessments. And that can be taxing and trying. And in many instances, as you actually try to execute on something, you find that the documents that you may be given don't contemplate every particular situation, or maybe you need something to explain things a little bit better. The board of directors has the ability to adopt rules and regulations on different things. Any rules and regulations, any policies that have been adopted by the board are not before you. Those are things that the board of directors would have the ability to do independently. Those are things that the board can do at its regular meetings. The one caveat to that is that boards need to act reasonably, and they need to comply with the bylaws themselves and the master deed and the governing documents. So among those documents, meaning the articles of incorporation, the master deed, the bylaws, the subdivision plan, which is the drawings that lay out the entire condominium itself, and the rules and regulations, what you're being asked to vote on are the articles of incorporation, which will update the documents that created this entity, the corporation that is the condominium association, and the master deed and bylaws. A couple things to, not asking you to vote on the subdivision plan not being updated, not asking you to vote on the rules and regulations, that's the board of directors. One thing that is worth noting about, that's unique to your condominium, there are a number of, not necessarily refurbished, but there are a number of condominiums that are created out of something else. It's not uncommon. Maybe you have an apartment complex that turns into a condominium. But Wordsmith Air Force Base is somewhat of a unique animal in that there are a number of provisions that existed in your old documents that needed to be carried forward. So you will most likely see references to the original deeds with the federal government or the county that deal with the creation of this. You may see issues in the master deed dealing with environmental matters. Those aspects needed to be taken out of the old documents and carried forward into the new. There were some things that just could not be stripped out and could not be changed. So those things that could not be changed or we did not want to change them, were carried forward, and you'll see those in the master deed bylaws. They make for the most boring reading. The things that I wrote are really exciting and interesting.
You almost get this.
So my goal in this was, I understand that you got a packet that's this thick, and it's not the easiest to read, and it's not the easiest to understand. And for the most part, those that serve on boards of directors are always volunteers, and they come from, pools of like this. They are ordinary residents that want to serve on a board. They want to give back to the community, and in many instances, they come back with the same knowledge base that you have, and they have to educate themselves about it and get up to speed. So part of my goal was to give you enough information that as you sit down and take a look at the documents, you can understand what they are. Randy gave you a pretty good explanation as to why many of these are being done, both to update the documents to new things that are in place and to update with changes in the law, but that you can take an intelligent look at them and make an informed decision. Ultimately, each of you has the right to make a vote, to take a position on it. You can vote yes or no. One of the things that we often see is that, when you add up the pages, it's something like 80 pages. I don't know the exact number, but it's in that number. And you may see on page 74, subparagraph A, that you don't like one little teeny tiny thing. And I call it teeny tiny because I'm kind of biased at the moment. But basically, what I mean is there may be some things that you don't agree with. It is almost impossible for you to look at for anybody to look at anything that is this large and agree with everything in its totality. And I can appreciate that. But what I would ask is that you take a look at it against the context of what you're being asked to do and the community at large. It is a thumbs up or thumbs down vote. You are being asked to vote yes or no as to the master deed and bylaws and as the articles of incorporation. You are not being asked if you like one particular provision or the other. So please keep that in mind as you choose to vote. You can vote separately between the articles and the master deed and bylaws. So if you disagree with the articles but love the master deed and bylaws, you can say that. But the master deed and bylaws basically go together, and the articles goes on its own separately. That's basically the process. At this time, I guess I would first point to the board to see if the board has questions for me, and then I would intend to open it up to you all. Is there anything that you guys think that I should cover that would be worth mentioning, or open up the floor?
You did pretty good, yeah.
Okay.
The floor.
Okay, so there is a microphone on that side. I would ask if, raise your hand, and I'll try and recognize. No one else stood up, so he's good.
Also, this is an informational meeting about the bylaws. We would ask that you contain your questions to the bylaws. There are different forums if you're upset with a lawn care or whatever. This isn't the time or the place for that. So please limit your questions to anything you might have about the bylaws.
Can I ask you to introduce yourself?
William Gaines, 8104A Delaware. I've lived in the community 12 years now. I have reviewed this thick document, and in the process of my review, I have several questions. One of the areas in there, and I presume that it comes from the Michigan State condominium bylaws, if a multi-family unit, either double family or four family, incurs a loss, this absolutely requires that the building be rebuilt to the original standards. Now, I know of only, in the history of this condominium, one building that has been burned. In that instance, the owners had lost a family member and were violently against rebuilding. This, in fact, gives you no options, requires the insurance company to rebuild, says that 66 2/3 of the loan holders of the condominium, and I would like to clarify you what in that context condominium means. Does it mean all of the units, or does it mean the co-owners of that specific unit? And how this is an onerous imposition from my perspective.
So the obligations regarding reconstruction and repair do come from the Condominium Act. This provision is not intended, nor is it a change from the former documents, nor from the Condominium Act. As far as its application to the potential obligations of that former owner to build, I'm not going to comment on that. That would have been a decision that they would have had to have worked out. But as far as the obligation to build, that does come from the Condominium Act, and it is not the board's intention to create a greater obligation than required by the act or was required previously.
Okay, the next thing that I personally object to is when I bought my unit, I had certain rights in that unit. One of the rights I had was to rent or lease that unit. This restricts my rights. In my personal opinion, I would state that I think that denigrates the value of the community, not appreciates it. My opinion, I understand that there are differences. I would just like to mention that in the bylaws buried, there's a clause that says obnoxious, immoral, et cetera, actions are prohibited. And I want to know who's the arbiter of what's immoral or obnoxious. In my personal opinion, I have personally been subjected to arbitrary and capricious enforcement of the bylaws on subjective basis. I have objected to it. I have objected to it strongly, sometimes in writing. And, I understand that morals are a very subjective area. When I was a young man in church, fornication was illegal as well as immoral. I don't think in our under 30 residents there would be any of them that would think that would be an immoral act. So what standard would apply? What standard would apply if I'm of the Muslim faith and my next door neighbor sunbathes outdoor in a bikini? Is that not an element that is just absolutely subject to interpretation?
I'll take it up. So there's a couple things. One is, as I had mentioned with respect to the rules and regulations, the actions of the board of directors is underlined by the requirement that they act reasonably in both their administration and interpretation of the governing documents. That's the floor. So there is case law out there that says it must exist. But then the question becomes, what's reasonable? In essence, the board is going to be guided by the bylaws. If the bylaws provide absolute rights to individuals, the board generally will not be able to take those away. They can adopt rules that help implement or guide people as to their interpretations, but they're not going to be able to take absolute rights away. The provision that you're talking about is it exists in a certain form in the current documents in section 5 on page 23, dealing with no one can engage in obnoxious conduct. It's not intended to be, nor is it something that is a panacea against which the board can say, we don't like this, so therefore you can't do it. The board at all times would need to be able to go back and point to something specific to say why something can't be engaged in or why something can't take place. In essence, in response to in direct response, I would say it's guided by reasonableness, and the board would have to rely upon the existing restrictions and the validity of any rules that are used to be able to guide its enforcement.
Okay, and I understand that, and, you know, my vote is that I don't very well trust the board to interpret reasonableness.
Right?
Long experience there.
That's a fair position. I'll take, if you got one more, I'll take one more, otherwise we'll move on.
No, I think that that's the basic
Okay.
issues. I have a long laundry list, and perhaps I'll indulge in that in writing at a later time, but.
Thank you. Sir, go ahead.
Has to raise our hands, but
If you're the only one that stood, so you're okay. But if there are multiple, if you see that there's more than one person that's looking to get up, please just wait till you're appointed, I guess. And then if you could introduce yourself.
thank you for your time. All right, so my name is Tim Cummings. I'm a resident, 9612A, Missouri. I'm also the trustee on the local Oscoda Board of Trustees, but I'm not here in that capacity. But I wanted to, first of all, thank this board and yourself for the assistance in getting this product. I've read 95% of the bylaws, and I want to tell you, I'm very happy with one particular component of this amended version, and that it removes all of the random and rather tedious amounts of numbers and measurements and quantities and things which were limiting and that really didn't even have founding or substantial law or ordinances or things which supported or conflicted with existing ordinances. It was really just nice to see that this was reduced down to something much more within the domain of this organization instead of trying to legislate from the inside out. Thank you for that. We've run into a number of problems at the township with being asked to support what the bylaws were and try to enforce them on behalf of the HOA, and I'm glad we won't have to keep doing that in the future. So thanks for that. Here's the next one. Following up on a question from Mr. Gaines earlier, the catastrophic damage. So I was reading in there because although it isn't a prevalent problem, I know that a neighbor just behind me experienced a rather disastrous accident involving their house, making it unlivable. And this particular home in particular, they couldn't live in it. So therefore, I would imagine that there's insurance money that's going to have to be transferred in order to rebuild or repair this home. And so in the language of the bylaws, it says that the insurance money is turned over to the HOA. And I wanted to understand what that meant because it seemed to, in the sentences there, imply that the HOA was taking on a project management role and that they would then be able to incur fees, charge fees to this. I saw this point about fees. So I wanted to ask you to explain what I may or may not have interpreted correctly on that point.
So, at least with respect to reconstruction, the way that I would expect it to work under these documents would be, is that somewhat to tail on the request regarding reconstruction before, but if you have the association is generally going to ensure the general common elements, and then depending upon language, and I just don't recall these documents, but sometimes the limited common elements also, if it's described as association ensures common elements.
Okay.
And then there becomes a question of primary versus secondary, with the co-owner, meaning each of you, at a minimum ensuring the unit, and then usually, and this is what I would expect, is also any limited common elements of which you are responsible for. And so you'd have, ideally you don't have any overlap, but sometimes you do. And then you most likely saw a primary carrier provision which deals with when one side has responsibility or the other.
Right.
In essence, ideally what happens is the association takes care of the reconstruction and repair of the general common elements and those things it's supposed to do, and the co-owner takes care of those things. And it's not really intended in every instance for the association to take over a reconstruction of things that it's the co-owner's responsibility to rebuild. There may be, in some instances, there's a possible issue. So for example, on the exterior appearance, generally the association has the right through the ACC to say what things are going to look like. And at times there may be a difference between who's responsible for building and rebuilding something and who's responsible for the cost of it.
Right.
And I'm going to give you an example. I don't know if this pertains, but it's easy to think about. Let's say decks. Decks are an area, let's say it's the co-owner's responsibility to pay the cost of responsibility of a deck, but the association has the responsibility to rebuild it if it gets damaged. In that particular instance, it may be a situation where the association comes in, rebuilds it, but the cost of that rebuild goes back to the co-owner. That is some instances, and I give you an example of a possible overlap.
Yeah.
I don't know if it's here, but it's one of those instances where there may be overlap.
Right, which makes me wonder why, so it suddenly becomes the sort of an imposing feeling on that, you see, because, well, I think everyone here understands we live in a community where we share that responsibility for the exterior appearance of our property. How do we adjudicate who is going to actually be, how do we adjudicate who's actually going to be controlling that rebuild? We would all like to think that our patios and backyards are still ours, even though we all share the visibility of them with the residents.
Well, that would be, the exterior appearance of it is something that would be determined by the ACC. So that's subject to their determination even presently.
Okay.
You would have the exclusive right to use it. If it's a
Right.
limited common element, your neighbor can't come on and say, hey, this is a common element, I get to chill out.
No,
you
but we're
can't
talking
happen.
about rebuilding and catastrophic damage here. That was the topic here. So
Yep.
let's not go off
Deviate.
topic.
That's
Yeah.
fair enough.
Thank you.
On an issue that's a common element, it is something that I would expect the board to have the ability to weigh in on.
Sure.
I do think that the administrative role is probably, I would not expect that. If it is something that is inside the unit, then
Sure,
I would
different.
expect that the board would have no
Agreed.
activity in that anyways.
Right.
That's how I would expect it to work.
Fair enough. Thank you. I think it's sufficient, and I appreciate the intention then, as opposed to the pure letter makes it sound rather onerous.
Well, I
Just as a point.
Right.
Okay, next topic here, and it was very clearly just, there was a concern in there regarding firearms, which I can appreciate our concern. We've had incidents here on the HOA, I'm sure you're aware of them.
it's
I also-
go ahead.
Go ahead. I also realize that there are a number of people here at in the HOA who are residents who are probably members of NRA and other such pro-gun groups. My concern here is not whether, in the bylaws does not refer to the owning of them, but the firing of them.
Right.
And the point there is self-defense. So is this person who has to use their gun to defend themselves in their home by law able to do so without then receiving retaliation from the HOA after the fact?
The
We asked that question.
I would, yes, and even if you take a look at the bylaw provision, you're not going to get fined for the first time. So if for some reason,
An interesting loophole, okay.
unless it's a reoccurring scenario, but it does say that, and the intention is you can own, you can hold, it can be in your, there's no intention to do that, but you can't, for recreational purposes, or for
Sure.
whether it's for hunting purposes, and it doesn't distinguish, it says for use, you can't do that. That would be a
Well, it just simply
violation.
says cannot fire. And that's the point.
I've been asked this before, and my response, and this is not flippant, this is a serious,
Go for it.
is that the bylaw violation in that instance is the least of your concerns, if that happens. And,
I understand.
And
And it is not flippant at all, you're right. But I guess my question here is, what exactly are we agreeing to by agreeing with the bylaws? That's what I'm trying to understand. So again, we're going back to interpretation and your intention.
you would be agreeing that there'd be no voluntary, there'd be no, you'd be recognizing that your use of a firearm would be in violation
Right.
of the bylaws as written,
Right.
and if you are going to be using it, it should be a significant enough event that it arises to self-defense.
I wish that language were in there, but thank you. So then, go ahead.
Yeah, well, and I don't want to speak for the attorney, but the way I look at these bylaws, this is a document that helps us live together as, I'll call it family members. However, we still got the laws of the state.
Absolutely.
And we still got the laws of the roads. There's so many times people come to the board saying, I want this or that done about the roads. That doesn't fall under our auspices. That deals with the county. Just as a firearm, as so many other legal items, the law comes in first. Just like our bylaws have to meld in with the Michigan Condo Act. I think we've done a good job of doing it. I think our attorney has helped guide us into that. I think we're
acknowledge
good.
that.
So I think you need to look at this as a document that help us live together as family members.
So,
Go ahead.
and one, just a tale to back up, which we see a lot, is that these documents are largely contractual. You know, the Condominium Act does set out certain parameters as to what they must look like and what must be in them and what can't be in them, but they're largely contractual. And so if there is a violation within these documents, your recourse is in this room. You know, it's amongst yourselves. It's the board of directors that would be the enforcement mechanism. It's not the municipality. Whether it's a municipal body, a county body, or the state, you know, they have their own sets of laws. And in a lot of instances, we see co-owners go to one of two ways. Co-owners will go to the police or go to the board of trustees, and they'll say, look, they're violating this particular provision. And the trustees or the police will say, our hands are tied, that is generally a contractual matter, as long as they're doing it right, and they'll leave it to the association. And so, as you look at those two things, those sources of what you can and cannot do, they're totally separate. This is a generally contractual matter involving all of you, with the laws and the ordinances of the state and municipality being something different.
Thank you. And then my last, go ahead.
One thing, Tim.
Thank you.
If you look back in your old bylaws, you'll see virtually the same statement.
Right.
And it
But
just carried forward. That was something that
Yes.
was imposed by the Condo Act originally.
No problem, and that's actually a good point. Is the source the Condo Act?
Not on
Because
the gun.
Okay,
Not on
good.
the gun thing,
Fair
but
enough.
for the discharge of the pellet guns, you wouldn't want somebody having a .22 range that pointed right at the back of your house.
Sure.
That was
right.
what they originally came about with the history of developing these.
Again, I'm not concerned about, the concern was about the incident of somebody needing to defend themselves.
Needing it, that could be a
That
violation.
was, in
and
other
being
words, there was a
addressed.
purpose for this.
We
And
brought
I
that
could
up to
imagine
the
that-
attorney before that was done,
Yeah.
with that exact statement.
And the fact that the language is the same as prior is actually irrelevant because we've negated a whole lot of language in the rewriting of these bylaws, and whether it's the same or not doesn't matter. I'm just trying to ask, why is this worded the way it was here? I actually liked your additional point there. I forgot your name, attorney. I liked your name, what you had said, and I wish that language were in the language that you had put in the bylaws. I think that additional qualifying sentence or two was really quite good, stipulating what it was.
Well, so in some instances, the board has the power to adopt rules and regulations which implement the bylaws.
Sure.
In some instances, you do have to stop short, because even though, so we're 20 years smarter than the original bylaws. I know these were recorded in '05, but
Right.
they're modeled after the '98 bylaws.
That's right.
And so
Yeah.
we've got 20 years of experience.
Yeah.
But we do need to think that we can't think of everything.
Of course.
And so it is within, and that's the purpose for the rules and regulations, to be able to, whether it's fill in the gaps or adopt different things.
Right.
But the general rule is that the usage of firearms is prohibited. That's the starting point. And as you fill in the gaps,
Yep.
that's something that the board can look at, but the starting point is you can't fire them.
And thank you very much for that. And then my last was just to tag on to another comment Mr. Bill Gaines mentioned earlier, and that was the concept of morality. I read that, especially since those were the first two words in the beginning of that particular paragraph. I was shocked to see that morality was the opening statement of that line, and that in that paragraph, it's defined that really morality is going to be up to the decision of this board, and that it is not refutable. I found that to be really concerning, since this board is indeed composed of volunteers who are not themselves professionals in any other capacity other than residents or property owners. And I worry about the change in the demographics or the change in social climate, change in other ways that will affect our ability to control what morality is in our minds.
So
And
I-
on that, I thank you very much, but you can continue to
No,
answer.
that's okay. I think I addressed it. Thank you. Thank you, Tim. Oh, go ahead.
Got
Come on
one
over.
right here.
Fred, do you want to try it from that side?
Can everyone hear me?
Yeah.
I was in theater. So,
Wait,
Can you?
yeah, because we're recording this to put on our website.
okay.
And so we got to be able to capture the voices. And I'm afraid over there, Tim may not be able to capture your voice. So your question's important, so if you kind of wander yourself over there, that would be very, very helpful.
See that right there?
Right there?
Yep.
Okay. This is a little awkward.
Well,
My name is Tora Williamson. I'm from 9814A Minnesota Street. We've lived here 8 years, my husband and I. I was not able to read the entirety of the packet. Unfortunately, I'm low vision. So I did the best I could. And I did have one quick question and another that's a little bit more probably complicated based on something that you said earlier. But the solar panels, is that allowed or not allowed?
They'd be allowed with board approval.
Sweet. And the other thing was, you mentioned that the mortgage companies get a vote.
Yes?
I was wondering how that weighs against owner vote, because we,
Yep. So I'll, go ahead, I'm sorry.
like for the people who own versus like how many, like I don't know how many mortgage companies own.
Yep.
Yeah.
So and actually, you're closing a loop on something that I forgot about. The whole reason I mentioned mortgagee votes. In your packet, you received a mortgagee form, and it asked for your mortgagee information. The reason we ask, and if you have no mortgage, please write no mortgage and send it back. The reason that we're asking for that information is for anybody from whom we don't receive that form, we need to verify whether mortgagees exist or not. And if you can think of 792, 752, 750, 750, if the Register of Deeds had to be searched 750 times, it can be pretty painstaking. And so every mortgagee form that comes back, in essence, helps keep the cost to conduct the mortgagee search down. The information is not being used for tracking the balance of your mortgage. Its sole purpose is to figure out who we need to send a packet out to. So that's tying up a loose end on my part. With respect to your question, they are separate votes. Mortgagees have the ability to tank a co-owner vote. So let's assume that this passes with 100% co-owner votes, and it's awesome. And let's just say hypothetically that one of the provisions in the bylaws say no one has to pay their mortgage anymore. Okay, 100%.
Yeah, please.
Yeah. Mortgagees get it, mortgagees read it, mortgagees recognize that their rights are now being significantly affected. Even though 100% of the co-owners said yes, they could tank the whole thing if more than a third, it ends up being more than a third of the mortgagees with units, or against units, came back and said no. Then it'd be no. That would end that particular vote process.
Wow.
But it makes sense though if you think about it, because a mortgagee agrees to lend money with the expectation of a certain level of risk. That risk is based on the payment history, the credit score, if you want to call it that, of the person doing the borrowing. How likely is this person to pay it back? But the other component to that is what is the security for it? And if I have to foreclose and take that unit back, can I sell it for what I think is the mortgage? And if they think that the value to them of the thing that they have a security interest against as being negatively affected, then under the act, they have a right to say no. As a practical matter, mortgagees generally are not that responsive, but they still have that right.
Thank you.
Yep. Yes.
Hi, my name is Penny Lee. My husband and I have owned a home and lived there for 19 years on 7th Street. Some of you may also know me as a real estate agent that helped you buy or sell your home. My question is about rentals.
Can you guys hear?
No.
Can Tim's
Tip it down.
adjusted it?
Can you hear me now? Okay, I'm Penny Lee. My husband Frank and I live on 7th Street. We've been there 19 years. We don't own any rentals. And I've been a real estate agent since 2007, who's probably helped some of you buy your homes. My question is about rentals, and I'm wondering if, when do these become effective, our new bylaws and such, once the mortgagees have their vote?
So the soonest that they, by law, they will become effective only when recorded. And it has to wait for the mortgagee vote to pass also. And so the soonest, as a practical matter, that these could potentially go into effect would be the November 1st timeframe at the absolute earliest, because that's the 7/20 date for the co-owner vote plus 90 days. I know that gets you to October 20th, but as a practical matter, it becomes November 1st.
Well, why I'm asking is, you mentioned the 25% cap on rentals.
Yes.
And the fact that there are people out looking to buy more units, and not very many more units would need to be sold before we reach that 25%. What happens if 50 units are sold between now and the time those become effective?
Well, there is so there is a provision in here which is intended to capture the interest of present people who are present landlords. You can call it a grandfather clause, because that's basically what it is. But basically, it allows those units that are being rented at the time the document is recorded, as long as they're being rented otherwise in compliance with the documents at the time, that unit would still be able to be rented going forward. That right would still exist.
But our interest rates on future sales of homes, purchases of homes, I should say, and our homeowners insurance could be adversely affected if we get above this cap of 25%, correct?
From what we've been told by a number of different sources, yes.
The benefit, and this is trying to meld two worlds, trying to weave the interests of two people who may have different views. You may have a camp that is, we want no rentals, we never wanted a rental, get all rentals out. That is a possible view that some may have. Then you may have another view that says, I have a right to rent, and whether I choose to rent or not, I will always want to have that right to rent. And that's another camp that exists. And this provision attempts to take the interests of the community as a whole and to say, how can we accommodate both and go forward? And that 25% mark is identified as in essence, it becomes a long-term goal. Because although you're just under it, so if nothing changed, you'd be right there. But even if you got over it, over time, as units sold and changed hands, you would still slowly slide down to that 25% mark, because that grandfather right to be able to rent would not go to the next owner.
Thank you.
I think it's important to understand, again, this document is to help us live together. We all drive cars. This may be a silly example. We all drive cars. I want to drive 100 miles an hour down the street because it's my right. I drive my car. But in the benefit of the community, it's better to control the speed limit. And I guess I can see folks that don't want their rights stepped on. However, if 90% of all the units now are rental units, and I'm the only one that has a home that I want, that I'm proud of, and inherently, sometimes some renters don't care as much. That affects me. That affects all of us. So again, that was the goal. Try to get something halfway, that is going to please, that is going to give everybody something. Doesn't please everybody, but it's a compromise. So I hope you look at that in that regard. It's a compromise. We do have a hardship clause there if you do have a problem. So don't let this stumbling block, please.
One other consideration too is any of you that are landlords, I think should be able to relate to this, that the more of anything you have, the lower the prices are. That's true with just about everything, gasoline, food, whatever. By putting a cap on the number of rentals, what's going to happen is that the price for those existing rentals are actually going to be more in demand, and you'll be able to get more for the rent on those rentals.
So we have one point. Oh, go ahead, Randy.
I'm done.
Hello, my name's Jim Helt. I am a landlord at 9720B, Massachusetts. And I actually agree with the 25% rule, and I understand that. My question is with the, the administration of that, of that policy. What happens when we're at about a minus 15 units, when there's one unit available to reach the 25%, and you have two people that are trying to buy two currently owner-occupied units? How does this board determine which purchaser gets to buy a rental and which one doesn't?
My expectation as the attorney would be that it would be whoever was first approved.
Yeah, first come, first serve.
If you had two people buy with the expectation that they could both rent, and there was only one spot open, and one guy got in and one person didn't, then the person who bought in with the thinking that they could rent but could not is going to have a difficult situation.
I mean, in theory, though, this is theoretical, but you could have two people, they both get approved, they both have a closing for the same date, they both sign on the same date, and now one person can't do it.
Yep, the way that it would work, though, is, as I mentioned to Penny, these become effective when recorded. And so any business, this is me projecting, but anybody who buys a unit has constructive notice of these documents, and if they're buying with the intent to lease, would have the ability to read that rental restriction. And my expectation and advice to them, if they were my client, would be contact that HOA to see what they're at, and they would need to make an informed decision as to whether they want to get in. But what the situation you're describing is a possibility, but that hardship would be borne by the last person in.
Okay.
It's called due diligence too. When you buy anything, you need to do a certain amount of homework to find out, is this a right fit for me? Is it going to work? And if you don't do your due diligence and you were that person that didn't get it, well, it's easy to blame somebody else, but if you didn't do your homework to find this out beforehand, that's not...
Yeah, but you
We've got some horror stories.
You as a board would have to enforce that against the other person that did buy it and say,
Yes.
no, you can't rent it. Right.
Yeah.
Yeah.
We've got some horror stories in here, and I think we want to keep this focused. Where folks, we contacted them about getting the HOA document, and they say, "What? HOA? What's an HOA?" Their realtor never told them when they bought the house that this was in the association. So Randy's comment is, you need to take due diligence when you do something. And what we've tried to do here with this document is to try to make it as fair as it can be for everybody.
So I know a couple people may want to ask second questions, which is fine. Before we get to that, is there anybody that, yes, ma'am?
You want to go the other way?
Okay.
Okay, all right. All right, good, thank you.
Pretty loud anyway.
Well, yeah, but we have to get it on the tape.
I understand.
Okay.
My name's Andrea Ho. I live on Virginia Street. I also have a home on South Carolina Street. Now, when I was reviewing the paperwork as far as going through things for the proposing of doing things to your home. There are many statements where it says certain units rather than which units can be done. For instance, the garage statement, you can't put on a garage addition or a garage to your home unless you're in certain units. It does not establish which units in the condominiums that are allowed to.
There is, in the master deed, there is a paragraph that describes those units that can't have garages. It's,
Okay, it's listed in the,
Yeah,
well, you know,
it's there.
when you're reading this thing, it's not very easy to try and determine
Yep.
where this is and where that is when you.
that's an example of something that was carried over
Okay.
from the,
Air Force.
the Air Force. Yeah, well, it's the Air, yeah, whoever set it up. It may have been an Air Force requirement, but there are certain units that, in the master deed, there's a paragraph, and I don't remember the exact language, but it says either can't have or won't have or must have.
Right, well, and I was just commenting on the fact that it does say certain units. I mean, does everywhere in there that says certain units, though, does it refer
No,
back
it
to?
lists
the
Is it listed
specific lot
specifics?
numbers that are prohibited from having a garage,
Okay.
and also lists the few units that can't have a garage unless they
It
remove
wasn't
the
just
lines under
garage,
the
it was just,
ground.
there was other items in
Okay,
there
so that would be,
that,
oh,
as verbiage.
so the, there should be no ambiguity. There should be nothing that says, certain people have, just to use a garage example, let's pretend that that paragraph regarding who has garages didn't exist.
Right,
There really shouldn't be anything that says, certain people can have garages. You know, because that type of discretion gives that's an odd, that I would not expect. What I do expect would be, for example, with the Architecture Control Committee, having the power to have control over exterior appearances in order to maintain
Correct.
aesthetics, or I don't remember the exact term, but to make it look the same as it has in the past. But the thing that you're talking about, I wouldn't expect that.
In the bylaws, we just looked it up, and it does specifically state, no garages shall be constructed on units 642, 648, 659, 726, and
Okay, so
747.
it was in the bylaws,
So-
it wasn't in the,
Then the reason for that is because when they built the villages, and when the Air Force had this, they ran certain sewer lines under certain areas.
Mm-hmm.
They don't want you building anything, a shed, a garage, anything over those sewer lines.
I understand that.
And
I
so it's deed restricted. That's not even us, that's deed restricted by the township.
I wasn't talking about specifically the garage, I was talking specifically about the word in different areas that just say certain as
Right.
units.
Do you have an
Because-
example?
Well, that was the only one I could remember was the
Okay.
garage one that I came across that, but I just wanted to
Well,
make sure that
it's,
there.
it's the
because
same
then
thing
then it
as,
gets-
it's the same thing as if you wanted to put a well in your backyard for
Mm-hmm.
irrigation. That's deed restricted, you can't do it, period.
I understand.
For any unit in here, it's not permitted. So there are restrictions, and not only here, but pretty much any subdivision, any city you go to, there are gonna be certain restrictions,
I understand that.
so.
What was the second half?
I don't even remember now. I just wanted to know why it was listed as certain and why it wasn't for other items as well. When it says certain, I want to know what the certain is because,
So for the restrictive language, I tended to carry over that which was in the previous document.
Okay.
And the reason being is that if you could or could not do something specifically to your land that was in the prior documents.
Right.
That was gonna, that's coming over.
because I guess my way of saying it, it wasn't really that it was specifically a garage, but if you're saying, well, that certain units can't put flower pots on their front porch, I want to know which properties can't. And I'm doing that as a tedious way of stating it. But I wanted to have it be clear and concise, and that's why I wanted to
Yeah,
make sure that.
and that's actually a good point, that I'll, you know, a couple things I was asked on the clause that said what you can and cannot do. A couple of people have said, hey, look, this is pretty open-ended. One of the things that a board can't do in looking at the question of reasonableness is waiver, estoppel, latches become part of a defense to enforcement along with something called, not exactly, but selective enforcement. if a board of directors says, everybody else can do this thing, but you cannot, that board would have issues potentially with the reasonableness of its conduct, because it would be unable to, if it is unable to identify a reason for doing that. That's, I don't know if that's the core of your concern, but
That's what,
that
yes,
protection, that protection
exactly.
exists.
That's what I was looking for, is to make sure that protection for everybody was in there, not that it was just one unit could build this and one unit could build that, and
Now, there
you
may
can't,
be,
because,
having said that, there may be circumstances where units differently configured,
absolutely, with
require-
water and this, I understand that.
yeah, that also exists.
Yeah.
Thanks. Yes, ma'am, I see somebody over there. You're okay.
I'm short, so give me a minute. Okay. I'm Penny Campbell. I represent an absent husband here, Tom Campbell also. We are at 9517A Montana. We bought in 2013 and will be moving up permanent as of hopefully the end of this year. As you can see, I've gone through it, and I have several questions that I'll try to be brief about it. One of them is real, I know it's going to be sensitive, and because of conflict between the federal law and the Michigan recently passed law, pot.
Right.
Okay. Since the use of marijuana is considered legal in Michigan for recreational and medical use, I understand that. But it is also considered illegal with the United States government, blah, blah, blah. I ran into this when I worked in my former field of working with the elderly. When somebody is using it on their private property, I understand that that's their right. However, if they're using it close to where you live or right next door in a twofer, that can become intrusive for the other person that is living there, especially in the case of myself where I am anaphylactic allergic to it. So what kind of, I guess, recourse would you have to be able to, if you can't talk to that person, to be able to negotiate or to work with that? Is there anything?
Well, so there is a marijuana provision in here, which you probably saw.
Yep,
It's the
read it.
beginning of Article 6. I don't remember if it's Section 1 or Section 2.
There's two of them.
But basically, the position that we're taking with this is to recognize your point in that the laws regarding marijuana use are evolving, but have not changed at the federal level. And so, in essence, if you read the provision, what we're trying to say is, look, you can't do anything illegal on your property. That's the starting point. We're not condoning illegal activity. The beginning is you can't engage in illegal conduct. However, with respect to marijuana use, the board is getting out of the business of enforcing those marijuana laws, largely because it's difficult to figure out, do I enforce it or not, when the state is saying one thing and federal law is going a different direction.
That's what I interpreted. So even if I call township police or whatever, they're not going to be able to assist either,
So there is, the way that I would describe it, and I'm not giving you advice in this respect,
Right.
but in some communities, we have, these tend to be in apartments where this issue comes up, but we actually have smoking prohibitions. And in those communities, we have similar marijuana provisions, but we have a companion smoking prohibition. And so if you have an individual who is smoking marijuana, well, that's enforceable under the anti-smoking provision, even if otherwise the board has said, we're not going to get involved whether you have a medical marijuana card or not. So the most that I can say is if the conduct itself, separate from the marijuana use, is problematic, and it is an obvious nuisance and a violation of municipal ordinances, or it's something to take up. But it is true that part of this is to say that the board is not, and the association itself is not going to be held liable for not enforcing federal marijuana laws. what it comes down to.
That's what that's what I kind of figured, but I wanted to hear it from you.
Yep, that's
Okay. The other thing that I wanted to ask about is compliance and enforcement. There are several areas in here that I had read with regard to what our responsibilities are in keeping up our properties and being able to make sure that we're in compliance in anything from making sure that our screens are okay, our paint is okay, our weeds are taken care of, our, everything. It seems to be sometimes we are indiscriminately enforcing that, and we try to understand all of that. And I think that with people who are out of town in terms of landlords, that seems to be where there's a problem. And I don't understand in terms of what you can do when all you're going to do is take a lien against their property for fines and things. If somebody is actually an absentee landlord and they're not even in the area and they're going to have to wait until you sell that property in order to be able to recover, what is that going to do?
Well, there's a couple things on there. One is no one really wants to lien against their property. That's, it's an encumbrance, it's a hassle. And two, you guys should know this, liens can be foreclosed. And so ultimately, if there is non-payment and there is money owed and there is a proper lien, then the ability exists to foreclose that and wipe out that owner's unit. That usually, though, is in delinquent assessments, not necessarily maintenance obligations and fines, normally. But it is the case that the tools of enforcement are set forth here, and the board really can't go beyond that. In essence, fines, lawsuits, liens, those are the tools that are available. And what would ordinarily happen is if it got to a certain point on a bylaw enforcement question, then the board of directors would need to decide whether to file a lawsuit seeking a preliminary injunction requiring specific performance with the bylaws, or enjoining them from conduct which may be a violation of bylaws.
Would it be appropriate then for the property owners to be able to be a little bit more vocal about those who are apparently ignoring their responsibilities of keeping their properties clean?
So you have a architectural control committee and you also have a board of directors.
Yes.
The board of directors is elected, and I can only speak from my experience. So every community is different. Every community has its own tenor, its own flavor, its own dynamics.
Right.
And I don't want to intrude on that. But generally, an active board, instances where a number of people wish to serve on the board, where you have an active community, those tend to be instances where boards are responsive. And seeing from the amount of time and the dedication that I saw this board, that's what I see. What I see sometimes as detrimental is, let's take an annual meeting. In some instances, individuals will see an annual meeting as an opportunity to identify does everyone know Seinfeld? The list of grievances that the father had.
Yeah, yeah.
And that tends to be counterproductive when done in that type of setting. Generally what happens is when it's best served, there's a complaint, a single complaint, a complaint is raised to the board investigates it. In these documents, there's a hearing requirement. If the board feels that there's a violation of the bylaws, it notifies the co-owner gets an opportunity to try to fix it. If it is not fixed, the co-owner will be fined, but before the fine takes place, the co-owner is given an opportunity to basically plead their case before the board, and the board then makes its decision. These vehicles are intended to run both ways. They're intended to give protections to the co-owner so that the individuals can't be targeted without at least some semblance of contractual due process, but also to take into account when things aren't done. But you guys have a pretty big community, and so my expectation would be is that there would be a level of tolerance needed and time to be able to work smoothly.
let me just ask this.
Yes,
Do you have a concern about something?
yes,
Did you make a written concern and turn it into the office?
yes.
Okay, and then it was not handled to your level of satisfaction?
It was taken care of, and then it came up again, and.
Did you make another complaint?
No, I did not.
Okay, that would be my suggestion. We
Yeah.
will work with homeowners if we've got someone not doing what they should do.
Would it be best
Within
to?
limits, you know, I mean, the board, we're all you.
Right.
We're you, we
Right.
represent you. If we got a concern, then by all means, document it again with some pictures, and we'll discuss this with this individual and say, look, this is the second time this has happened. We've had a number of these. And again, I don't want to conduct board business here,
Right.
but what we're trying to do is get through the get through the questions that are here.
Right.
So the documents give the opportunity for both sides to address it. Raise
Sure.
the complaint, written complaint, and then the co-owner can raise however their defense goes.
And the last thing I wanted to ask you was, on your website,
My website or this website?
the website for the association,
Okay.
is there a spot, because it seems that, I use an iPad, and it seems to not be able to let me into certain areas of the website. And I'm looking for the meeting minutes for when you folks meet with the board. Is there a spot for that, or should I be using a full laptop to be able to do that? Because I'm having some trouble. And I just wanted to express that.
This is getting kind of outside this.
Oh,
Maybe
I'm
what
sorry.
no, I mean, that's a good question. Take your name, let's get with the office, and we'll get this resolved
Okay.
after the meeting,
All
okay?
right, thank you for your
Let's do
time.
this. Thank you.
Thanks. Oh, yeah, no, sorry. That's okay. Did you just have another one? Was there somebody
Hi
else?
there.
Somebody less back over here.
I hurt my leg. Anyway, my name's Dave Betts. This is my wife Kathy.
Dave.
And I'm sort of what? Can't you hear me?
Come here.
Not the
Yo,
mic.
Dave.
I got a big mouth, nobody can hear me.
Here,
The mic.
stand right there, we can hear
Okay, can
you.
you hear me now?
Yeah.
I just wanted to make a comment because Kathy and I, plus some other people, worked on these bylaws for a long time. I didn't work on as much as some because I got some medical issues and take some time off, but the bottom line is I'm listening to some of the comments that are well warranted, but I keep thinking that everything is not perfect. Tell me one thing in this life that's perfect, and there's nothing like that that's perfect. But in order for us to move forward, to gain a lot and maybe have questions about a little, is why these bylaws are out there. If you could have read these bylaws, you would have probably, and had to debate with 7 or 8 or however other many people we had on that board. And this is nuts, So everything, basically, with a few exceptions, is good to go in my book. And believe me, we went through this with a fine-tooth comb. Some of the issues we're discussing is not particularly in line with what the bylaw transitions are. But a lot of them, most of them are. So I think we have to, like you said earlier, we've got to take the whole total picture on this. And as most of us know anyway from some of the comments, that this is an absolutely, an unprejudiced, necessary thing, with some exceptions, but we have to manage the exceptions. It's that important to you, the value of your home, the value of your community, all those things are dependent on this. And as I look around here, I see maybe, 50 people, 80, something like that. And how many people do we have in the community who bother not to show up? They have something better to do, right? I know we sort of tried to spread the word in our community, our area on 6th Street, but still. So the necessity for us to get a 2/3 vote, yes or no, but a 2/3 vote is gonna be critical, guys. And we need to go out and knock on doors if you can't. to trying to get these people to recognize the responsibilities of being an owner in our community. And I'm really adamant about it, because if some of these things could just, if it doesn't pass, we're gonna have a new road to haul, in my book. But again, these bylaws weren't transitioned prejudicially in any way, but our intent was for the best of all our friends in our community. So, and I don't know if I'm talking wrong, whatever, but it's the importance I see. And some of the things are not trivial, but the mass of the whole concept is based around the improvements in the bylaw. So I just wanted to say that. Thank you anyway.
All right, so there, were you the one that had your hand, somebody on this side had their hand up? Okay.
Wayne Fortney, 9758A 8th Street. Please bear with me. I'm on heavy medication, so I'm going to ask Mike and any other garden club members to help me out here. Mike back here from the ACC committee to help me out. We have lived here for 13 years. The first year we were here, we joined the garden club. And so that's that. 3 years later, I joined the ACC committee. We have worked so hard to make this place better, but yet there's some people, like Dave just said, they got some buffalo chip crap that is nothing. If you got a problem, there's a complaint form over it. There's forms over there for asking to have stuff done. You have no idea how many people don't pay attention to that. Somebody else said earlier about people doing things that they're not supposed to. One good example over in Alaska. Yeah, this lady putting in this chain link dog run. Oh, again, same thing. Oh, realtor didn't tell me.
Well, is there a question on the
No, there's not a question. This is just a statement.
Okay. Wayne, I appreciate it.
Okay.
And I love your concern. But I want to make sure that we take this time to talk about the proposed document. I feel that it's better than what we are currently living with. And if we don't pass it, we're going to have to live with something that's a heck of a lot worse than this. So you've got a concern about the proposed document. That's really what we want to address today. And I appreciate.
I'm going to say one more thing.
Okay, say one more thing, and then.
And this is
all
with
right.
regards to landlords. Oops. Okay. I basically don't got any use for them because I had a guy from California come in and buy the one next to
Okay.
me.
That would be good to bring to the board meeting. Bring
Yeah.
that to the board meeting,
Okay.
okay?
Thank
Are
you.
there any other comments specifically dealing with this that we can address? Let's go back here, okay? Let's get over by the mic, okay? Thanks.
He's up.
Okay, that's all right, go ahead.
Thanks.
We'll wait.
We got one guy over here.
All
who's
right,
next.
all right.
That's okay.
I've got one item that pertains to parking restrictions. There were 8 lines in the bylaw deal there. And they said the vehicle should be parked only in garages, driveways, if any, serving the units, or in other areas designated by the association, which parking areas may or may not be assigned spaces, and parking shall be subject to rules and regulations of the that the association may adopt. Then the very next paragraph, it says, association rights to sticker or tow vehicles. And then I'm imagining that you're gonna have signs on all the streets, no parking. And then anybody parks there, you have the opportunity to go around and put stickers on the vehicles, perhaps, and then they're supposed to be towed away. And then it goes on to say that the co-owner, or if it's a tenant, actually it'll be the co-owner that will be responsible for that. You know, I just don't see the parking as an issue anyway, I realize that. Like Alaska Street, I don't know how this is gonna work because no place to park on Alaska. There's,
Let me address that. It's been an issue ever since the first day, and especially in that area of Alaska and in those streets in there. Understand that the county owns the roads and the signage for those roads. We have no control whatsoever over those roads. We can't enforce parking on it. We can't repair them. Now, you've probably all seen the repair work they're doing out here in Bissonnet and Mission. I think they got tired of us calling every week, telling them about the potholes, and they said, you know what, heck with it, we're just gonna repave it so they'll get off our back about it. I don't know if it made a difference or not, but it's getting done. But we have absolutely no control over the streets.
There is a no winter parking.
how can you, if you don't, if it's a public drive, then it doesn't belong to the association.
Correct.
And then it's stated in here, I wrote it out from what I read of some of the other stuff, that you can impose a fine or vehicles are, impose a fine or for ones that are illegally parked on it.
For there to be
And so how can you do that when it doesn't belong to the association?
For there to be a fine, there would need to be a violation of some parking limitation that exists. There is a parking limitation with respect to winter parking.
I realize that.
And that is in here. And so in theory, the board could enforce as a bylaw violation an individual who parks on the street in the winter months, even though it's a public street, because contractually it would have been something that everybody would have agreed, even if it's only a 2/3 vote, that they would not do. And otherwise, the towing and stickering is intended to bring the documents. There's a towing and stickering statute. So there's a Michigan statute that I think is cited that says what you must do in order to tow. And that's intended to comply with that. So the steps
It
if
did
towing
say
were to
that
take place.
if you were gonna tow it away, you didn't give the person the opportunity, you know, when they had the sticker on the window, to move it. It was gonna, and if it was moved, it didn't matter.
I think it's 24 or 48 hours. I don't remember the time period. There's a waiting.
No, I didn't see that in there, but that.
72.
Okay.
That's
Well,
under
can
the
I
act.
add something to that?
That's in the, well, that's in the act. That's,
But we could put all
like,
the facts in here.
the Michigan law on towing and stickering would need to be followed for anything to be towed. And that sets out what an association would need to do. First and foremost, there would need to be a violation of something. If you're parking your car where it's permitted, then it's permitted.
Okay. All right, I had another issue on leasing of rental units. There've been some changes on that, and I understand that the homeowners association is going to create a form that will have to be added to the forms that landlord has been using in the past. I mean, it'd be another form probably to fill out. It stated it in the bylaw.
Well,
So if you can explain that to me.
So are you talking about the review, the need to have the lease reviewed and approved?
Yeah, right. There was a 10-day period of time that
So
they're going to
that-
make the,
That language is actually, that section, it comes straight from the Condominium Act. And the intention of that, one, it's almost word for word from the Act, MCL 59.212. But it's also intended, any lease is supposed to reference and incorporate the master deed and bylaws. And that provision is required to be in bylaws to give the board the opportunity to make sure that tenants are being told by their landlords that they're subject to the condominium documents.
That's a 10-day,
Yeah, so yes, and the goal is, at least under the Act's provision, to give the board enough time or a reasonable amount of time to figure out, okay, is what's being proffered to this tenant compliant with our documents, or at least notifying them of the existence of them. And that language comes from the Act, Section 112.
and then there was one more issue. It said that there was a fine that could be implied or added to the process through the homeowners association.
It may be an administrative fee for renters.
It's an administrative fee.
Is there one for renters?
What he's referring to is our leasing packets. We have a packet that all renters must fill out, or landlords must fill out, and it does state in there, if it's not provided to the association within 10 days, there's a $25 fine. That's a rules and regulation policy, not a bylaw policy.
Okay. There is also, though, for renters, so you would know, on page 25 of the bylaws, the board would have the ability to impose a lease service charge. So if somebody has to come out to a unit that's being rented to do something, there can be a charge associated with that.
One thing that's happening, and that we frankly don't want to see get any worse, we and our office staff, they're not rental agents. Okay, they're here to continue to run the HOA. But as the number of rentals grows, they're spending an inordinate amount of time dealing with the rentals. And it's taking away time that should be spent dealing with HOA business. We don't want them to be rental agents. That's not what we are. That's not what they do. But they're forced to deal with it. Like when a rental unit has shrubbery out of control, hasn't been cut in 10 years, they have to deal with that, and they shouldn't have to. And it's been getting worse and worse and taking up more and more of their time. That's why there was a consideration to do an administrative fee when they have to deal with these. So it's not to punish anyone, it's strictly to help offset the inordinate amount of time that they're having to spend with these.
Bottom line is, if you got a rental unit, take care of it.
Yeah.
Take care of it.
All right, we got a couple more. I think he's got a question. I know you had a question, and then
Yeah, we're gonna wrap
You
this
got
up.
one. Go ahead, sir.
Good morning, folks. My name is David Monk. My wife is Sandra Monk. We own a rental on 9712A 7th Street. And we did do our due diligence when we bought the place that we could rent it. So kind of by what you said there, and now you're trying to pull the rug out from under us renting. And because I got my daughter, willed my place to my daughter, and that would technically be change of ownership, and then you will stop me from passing that on to her. And then also you said that you're kind of looking at renters as like they're slumlords. Well, I've seen some homes over there too where the shrubs are out of control and people don't take care of their places. So that's not a true statement about renters not keeping up their property. That doesn't hold true across the board.
No, it doesn't. It does not hold
Well,
true.
that's what you said, and
Well, that's not what I said.
that's not fair.
Sorry, it's not.
So what, that I don't think it's appropriate that the HOA knows how much my mortgage is.
We don't want to know. Don't tell us. We just want to know who it is.
All right, I thought I read in there that they needed to know how much our mortgage was.
Don't want to know.
No, we don't.
Okay, that's
There's no interest in that whatsoever.
And for other people, most people here are elderly, might be snowbirds, going to Florida. That's gonna hold them from renting their place for 6 months to keep it occupied. make sure the furnace is working, no pipes frozen, broke. And you're taking that option away from them to be able to do so.
There's absolutely nobody doing that.
That's not happened. That has not happened. 0 times.
All right, if these folks here wanted to go to Florida over the summer, their second home, and they wanted to rent out their house, and you're at your 25% quota, they won't be allowed to do that, and they own the place. They should be allowed to rent it if they'd like to.
All right, so I understand, so you oppose it on the basis that you believe you came in, you should be able to rent, and there are reasons that people should be able to rent that aren't being taken into account.
I believe everybody should be able to rent, regardless.
Right.
I think you're
Well,
you're pointing the finger at landlords, and I'm sure you got a few slumlords out there. I don't disagree with that. But that's not true across the board. We take care of our place, and I've rented it from day one.
Thank you very much.
And
That's fair enough. And that is, so everybody knows the process is that the reason there's a vote is because not everybody is going to agree, and it is appropriate for you to hear other positions and other arguments. That is fine and should be taken into account. Do you have any other questions?
yeah, how much legal fees does this run us?
This was all budgeted in last year's, 2 years ago, actually, the budget, because it's taken us 2 years to do this whole process. I'd have to look right offhand, I can't tell you that without the budget in front of me. It wasn't cheap, but it was way overdue. Can you name me one other thing that's gone 20 years and not changed? Our bylaws have, they've gone since the day one inception.
As far as
nothing-
I'm concerned, the bylaws were just fine the way they were.
All right, so do you have, you asked about the legal fees. What I would do is I would go to a board meeting and ask, or I would figure out a different way.
Yep.
Do you have any questions about the documents?
Yeah, in some ways, I feel the HOA is overstepping their authority. And I feel that they're kind of picking on landlords that are leasing the place. And I think that we're being singled out over this. And the changes in the rules and regulations is certainly pointing that way from my side of the table. Trying to
All right, thank you.
keep it to a 25%. It's better to have somebody in the place keeping it up than having vacancies.
Thanks.
Thank you.
And if the place is full, the rent and value will go up,
Let me
not
say
down.
Let me say one thing. I'm the president of the Homeowners Association here. I am also the manager of 2 rental units. My family owns them. I don't. Actually, my wife's family owns them. So when we put together this new bylaw packet, anything that applies to you applies to me and every other board member on here. Now, we tried to walk a very fine line so as to not cause any harm or distress to anyone, whether they're a landlord, whether they own 1 unit or 20 units or no units. But this is an issue that we have been asked about. Like I said in my opening statement, we've been talked to about these rentals more than everything else combined. And the common question was, what are you going to do about the rentals and when? Well, this is the opportunity to do something about it. We've tried to be fair. We've tried to be reasonable. We don't want to take away anyone's rights. We understand that. But if this doesn't change and it keeps getting more out of control, all of us, excuse me,
More rentals.
Excuse me, let me finish. Because again, we have had from 2 independent sources that an investor wants to buy 50 units in here. Do you want your insurance to go up?
I wish I was him.
But that's not what I asked. Do you want your insurance to go up on your house? When you
My
go to sell
insurance
your,
will go up if the place
excuse me,
is
can I
vacant.
finish, please? When you go to sell your house, are you gonna want that buyer to have to pay a higher interest rate because he's buying in a rental community? Because that's what we're facing, and we're trying to put a control on that. Now, if you don't agree with that, that's your privilege.
I don't agree
That's
with
fine.
it, because if I sold it, actually, it's willed to my daughter, and a change of ownership, you guys are gonna turn around and say, well, she has to live there or sell it now, because she can't rent it out. From day one, when we bought the place, we rented that place out, from day one. And now that's changing, and it affects me.
I don't know how you own the unit, but I would look at how it's owned. Whether you own it in a trust, whether you have a corporation, whether you own it individually, I would take a look at,
What would that really have to do, because the homeowners association would supersede that as far as what she's able to do, continue on?
That's all I would suggest.
Not in a trust.
Right.
If it's in a trust, then the trust takes over, right?
He'd have to look at it, but it may not change.
Right.
Ma'am, I know you have a question. I'm gonna ask you to sit down, unless you have anything additional.
Well, I kinda do, but I feel like, you
is
just
it-
wanna push me out of here.
Well, is it different than, well, hold on, is it different than leasing? Sir, is it different than leasing?
I'm sorry, I didn't hear you.
Is it different than leasing?
Yeah, kinda.
Okay.
You mentioned in there, if I think I read it right, about you wanting to be able to solicit, go around and to door to get people to vote and stuff like that?
So I wrote a cover letter that I think you guys received and indicated that, hey, you may have people come to your door as part of the process. Yes, I think that was in the
Well, I
cover
don't
letter.
think solicitation is appropriate. For one, my tenants can't vote anyhow. So, you're bothering them kinda. And something about being able to put a sign in your window or condo to vote for you. Did I read something about that?
Not that I know of.
No.
Okay, because, we're not even allowed to put a for sale, for rent sign in ours,
Well,
and I thought I read somewhere.
Well, you did-
I didn't have much time to read this.
Right.
Because we just got this the other day. I went in for knee surgery. I was hoping to have this package sooner than that, so I'd be a little more prepared but this is really about all I could, pull out at this moment.
Okay, thank you. Ma'am?
While she's getting to the microphone, let me say one thing too. If any of you have additional questions that you think of between now and whenever, you're always welcome to come to our monthly board meetings that we hold once a month. We will be happy to tell you the day and time that they are, and you can ask your questions at that time. We'll answer anything we can for you. The typical number of people that we have come to our board meetings every month is 0. Okay, so if you have questions, please attend. Ask us.
Please call the office, tell them you have a written question. If we can't answer it as the board members, we'll ask our Matt to give us a legal interpretation.
And you're probably going to come up with questions after you've had a chance to read this. We get that. But if you do, come to the meeting and ask. You don't have to stay for the whole meeting. Ask your question, we'll answer it. You can be in and out in 10 minutes, if that's what you want.
So we've got, she has a question. I know you have one more.
She has a question.
Okay, go ahead. But we are going to wrap up pretty soon, just so you guys know. Go ahead, ma'am.
My name is Dee Morand, and my husband is Tim. We live at 9204 Rhode Island Drive. And I came here because our street has several rentals, and we have houses for sale. And I had concerns about the fact that our neighborhood is becoming somewhat of a rental area. And when we purchased our property, of course, that wasn't what we wanted. We wanted to live in a neighborhood where you get to know your neighbors. But at this point, I'm sort of looking at this and I'm trying to understand if I'm getting this correctly. If this does not pass, then we are vulnerable to a situation where we have no control and somebody can come in and buy 50 units and rent them out. So we're sort of in a do or die situation, is the impression I'm getting on passing this.
Well, there is a leasing provision that would need to be complied with. It doesn't contain a 25% limitation, and the Condominium Act does describe what a landlord must do in order to rent. But I'm unaware of a leasing cap in your current documents.
Right. All right, so we are in that situation where it is very possible that if this doesn't pass,
Yep.
Yes,
okay.
that is true.
That's what I wondered.
It is a landlord, and this has kind of gone back and forth too. Compliance with the documents applies to everybody. You know, just so you know, like co-owners, tenants, it may be more difficult to enforce it potentially, but everybody is supposed to comply with the same documents. That's all.
What percentage of rentals are we at
We
right
have-
now? Do you know?
I think they said just under 23%.
We have two people here,
Thank you.
I think she had her hand up first,
Yep.
just because it was before.
and then we have Christina over there.
Yes, I have, okay.
I'm Mary Jo Richter. My husband Gary and I bought in 2002, and we've lived here since 2004. We've been, because of some of the questions that people have asked prior, we've been living with this situation. We live at 95, 17B Montana Street, and we've been living with a marijuana grow operation in close vicinity to our property. And since we're in a multi-dwelling, what folks do in the other half sometimes impacts the other folks. Is there anything that I'm missing in these documents that could address going forward?
Well, without knowing the specifics, what I would suggest is look at the permitted use provision, which is Article 6, Section 1, which requires that everything be used for residential use. There are certain at-home office uses that are listed and permissible. I think there's 5 or 6 or 7 of things that are permitted. If you believe that it is an ongoing business enterprise that is taking place, I would look at that as a means of potentially limiting what they're doing.
Okay.
But if it's not a violation, it wouldn't be enforced. It wouldn't be a violation.
And since we've talked about the rebuilding situation, if there was a fire or some catastrophic thing in the other half,
Of a shared unit?
the other half of the unit, do we even know if our insurance would take care of that or would consider that as something that they would not pay?
You mean the associations or yours?
No. Each of us have to have insurance to protect the other half. And if something like that happened in the other half, would the insurance companies not pay because something illegal or something that caused the damage that they won't insure for?
That, I don't know. That would be a necessary conversation with an insurance agent regarding that level of risk exposure. I don't know the answer.
But if you ask your own insurance agent, the red flags are going to go up. Okay? So I want to know if anyone on the board has ever checked into any of that to find out if we are at risk that we don't know about.
I'll tell you what we have checked into on your specific case. We are aware of what you're talking about. We started out with the city police, the Ascota police. They couldn't do much for us. So we went to the sheriff, same thing. We went to the state police, same thing, can't do much. We contacted Sting, which is their drug enforcement division of the state police. Same thing. All we were told was because of the population density that a grow operation would not be permitted within the villages of Ascota, a legal grow operation. We said, well, and they even checked to find out, is that licensed? The answer was no. Okay, what's next, we ask. They said, we can't do a thing until we have probable cause to go in there and bust the place. Well, how do you get probable cause? They try to send people in there, undercover people, to buy stuff, they won't do it, or they couldn't get them to bite. You can't just kick down a door and go in. That's not what they let you do in the United States. So we're stuck. We know it's there. The lawn crew, every time they cut the lawn, just about gets stoned just driving by the basement windows because they put a air exchanger in there. It's amazing how many breaks they take beside the house, but, you know, so
Have
we're...
you made a formal complaint to the police department?
We went to.
Yes or no?
No, they wouldn't even talk to us because
Have
we
you
went.
called all of the
went-
police departments? Have you
we
called
went to-
local? Did you call sheriff? Did you call state police?
Yes.
You did?
We've been there in person. One told us, in Tawas, the state police, that we needed to go to Alpena. We went to Alpena. Alpena said, you gotta go to West Branch. I mean, it's just a big,
See, the police are as confused as anybody else, because the federal law says one thing, state law says something else, and we don't even allow businesses to be run within the confines of the villages of Oscoda. Well, if they got a grow operation and they're selling it, sounds to me like a business. So, you know, again, without having probable cause and proof, there's not a whole lot we can do, and sometimes homeowners expect us to be the police. Well, we're not. We don't have the authority and the power that the city or the sheriff or the state police have. It's not who we are. We're a bunch of volunteer board members that basically have no authority when it comes to legal issues like that.
Ma'am, what I would suggest to close it out is if you read the new bylaws, take a look at Article 6, Section 1A. If you feel that that activity is violation of Article 6, Section 1A, then write a written complaint to the board once it's adopted. That's what I would suggest.
okay. Thank you.
Anyone else?
Ma'am, I know.
We keep talking about this 50, guy wants to buy 50 units in here.
Hey,
I can't hear you.
Kathy, and besides, I think Christine was first.
Oh, she was? Sorry.
Oh, okay.
You gotta come up to the mic, though.
Okay, I'm Kathy Benz. I live on 6th Street. I have been informed that, so correct me if I'm wrong, this 50 units, is there or is there not Michigan case law in Dearborn, Michigan that says our homeowners association, if we do not want to sell to this man, we do not have to. There is case law in Dearborn, just recently, case law in Dearborn.
You're talking about the Dearborn West case. That's a rental case.
Yes.
Yeah.
He wanted to buy 15 units. 5 units or 15 units? I've got the paperwork.
That condominium did have a rental restriction.
Okay,
We don't.
that's why we've got to get one.
And we're a
Okay.
site condo, so we don't own the units.
Yep.
Man. All right, so 2 more, and then I have some written questions that I'll respond to, which you have given me.
Okay, now my understanding of the limited
Your name and address.
Oh, Christine Dillon, 9757 8th Street. The limited common elements, from my understanding, would be attached garages, additions to the house, separate garages like on the single units, not the quads, and that the association and the board of directors decides that they want to do something on your property, that they have the right to tear down your garage, your addition, to do whatever they decide they want to do, and that the owner would be responsible for replacing said garage or addition that the board tore down for whatever purpose they had for going on your property in the first place. That's my understanding of all of these rules.
The Architectural Control Committee would have the ability to, if you want to make a change or if you want to construct something. I know what you're
No,
asking.
that's not what I'm talking
I know, but
about.
let me finish this out. If you wanted to do something, the Architectural Control Committee would have the ability to say yes or no. If you are not maintaining something, if you are letting it fall into disrepair, then the association would be able to, one, tell you that you need to bring it up to whatever maintenance standards exist, and if you refuse to do it, then the association would go to court to get an order that says we can fix it. I'm unaware of a provision that would allow the
No.
association to tear something of yours down.
No, the area, what I'm reading is that if the association, the board, decides that something that they decide needs to be done for the association, and it's on it's part of your property, that they can go on your property and take down your garage, take down your limited common element.
No, that's the abate. That's what, if you are supposed to maintain something and aren't
No,
maintaining
it didn't have, it doesn't say the word.
Why don't you reference this as
I
the
can't
specific?
because it's
Well,
a
then
little
sit down
difficult.
and look for it,
Hold on one
please.
second, he's got it.
Mike, you are extremely rude. You are very rude.
He absolutely is.
All right, so if you can. I have it right here. You want, is this easier? So that's the master deed. The bylaws are a couple behind it.
I think he's back. Here's the
Do we have anyone else that has any questions? Yeah, this will be our last question.
He's got it too. Christine, he's looking for the same thing.
I scanned through the documents, so this might have been in there, but after these are approved, if, I'm assuming they will be, hoping they will be, and something needs to be changed later on, what's the procedure? Like if somebody's, if enough homeowners are unhappy with a particular section, how do we change it later?
So as I indicated before, this is a thumbs up or thumbs down vote on this process. So, and they're out there. Let's say it fails, all right? So we don't get 2/3 vote. Then the board would need to assess if there were particular provisions that didn't work, and would need to do another thumbs up or thumbs down vote with or without that particular provision or provisions.
But if we can get it passed, and there are things that people want to
Like,
pick at later, or new things come up in a couple of years, how do we change it?
So this is a rewrite. So this is an amended and restated set of documents for the master deed and bylaws. It is possible that you can have singular spot amendments on singular issues, depending upon whether or not those affect co-owner rights. If that has a material effect on co-owner rights, it would need to be submitted for another 2/3 co-owner vote.
Thank you.
Page 13.
Good question.
I think I'm right at that page. Where I was. Is that page 13, the amended bylaws?
Is this co-owner
Beginning of the master
responsibility?
deed. Under the master deed.
So is it the provision that begins the co-owner of the unit will promptly repair?
No, it's, page 13 it's number 4.
Co-malfunction?
Addition and modification.
Yeah, except for it says,
All co-owner
should
additions and
the
modifications.
association require access to any element of the condominium which necessitates the moving or destruction of any or part of any such addition or modification, all core costs, damages, and expenses involved in proceeding access and restoring the addition or modification will be borne by the co-owner. That tells me that they're actually being given permission to come on my property, destroy my property for whatever reason that they said, because it doesn't say anything here about they are maintaining
Right.
anything.
So that is not an independent grant of the ability to do it. What that is indicating is if it is necessary to do that, say for example, somebody goes south for the winter and doesn't maintain the heating in their unit, and there is a flood or there's a leak or there is something that needs to be done, and if the association has to come in to take care of it, then the cost of taking care of that thing is going to be borne by the co-owner. That's what that provision does. The association, in the absence of a basis for doing it, in the absence for either a failure to maintain or if the co-owner has constructed something that was done without having obtained ACC approval, and if ACC approval is required, in that instance, the association could come on to take that down, but to do it, the board would need to go to court to get an order permitting it to happen. That's how that would work. It doesn't provide an independent, what it doesn't do is it doesn't say the board has the independent ability to tear down something of yours that was properly there. That doesn't exist. It would need to be a basis for it to be addressed.
Okay, I'm
Yeah,
still
the
not.
language, that's pretty gray area.
Well, yeah,
basically-
I'm still not understanding why a person's garage that is attached to their house is considered a limited common.
It says it's not.
element.
So one of the things that we made no changes on is whatever you bought, you have. One of the things we did not do was alter the relationship between your unit, a limited common element, and a general common element. Just so you guys know, with respect to an ownership standpoint, each of you individually owns the thing that's called the unit. That's what you own. And the rest of this entire project is a common element which is owned by you as a group. Like you own 1/750th. But the limited common elements, only you have the right to use your limited common elements. You can box everybody else out. And it just deals with a little bit of ownership. The exterior appearance, subject to ACC approval, but that's the ownership concept.
I
Let
think I
me
can
just make an
clarify
example,
that.
and- well, Okay, well, let me make an example. She walked away, but let me make an example of maybe with this, drive this home. For example, you put a sunroom on the house, and it's over the sewer line, okay? And your neighbor next door has a sewer problem, and we have to excavate the area where this sunroom that you put on the back of the house to get to the sewer line. At that point, we'll have to demolish the sunroom, okay, to get to an area that needs to be repaired, a common area, because the sewer line is a common area between the two houses. So I think that would be an example where this would be. Maybe it was approved by the ACC, shame on them for approving it,
Or the
but
Air
it's
Force.
over, pardon?
Or the Air Force.
Or the Air Force, yeah. Maybe it was a sunroom. In this case, I think that's where this would apply.
Tammy, did you have?
No, he said it right
Okay.
there.
Yeah, we do have that.
Yeah, no, you may as well stand up. Now's the time.
You didn't actually answer my question as to how the word condominium that is used in here a number of times is defined. When you say 66 2/3% of the mortgagee holders of the condominium.
Yep.
What does condominium mean in that context?
It is the physical parameters of Villages of Oscoda and all the mortgagees that have recorded against units in that condominium, in that space that is the legal description of the Villages of Oscoda.
Then my understanding, if the other half of my building burned down, or if my half burned down, I would have to have approval of 66 2/3% of the first unit mortgagee holders in order to not rebuild that.
That's what these current documents indicate.
Okay.
Meaning the documents that are drafted.
You better build bigger and better.
Well, the other thing, Randy, you talked about due diligence. Several years ago, you guys revised the RV rules. I own an RV. I earned it when I moved in here. You took away some of my rights when you revised them. I objected violently in writing. Now, this says that the board will change the RV things that, I think the word is is at their discretion. Again, I find it really hard to accept that in an area where I did due diligence. Unlike a lot of people, I did read that document when I bought. And had the RV provisions not been what they were, I would not have purchased.
So that, one of the things to take into account is that part of a condominium is a balance between a community living and the Condominium Act's allowance for changes in the bylaws to take place among that community, and instances where an individual has their space and has what they want and their independence. And that is a balancing. There are a couple quick questions that I had. Marilyn had a couple questions.
You can answer later.
Well,
Yeah, but it
I may
costs
as
us
well
money
just get through
to
them.
do
Yeah, we're losing our crew here.
Okay, so what are the consequences if the new rules do not pass? Her concern was that the state would appoint someone to run the villages of Escoda against our wishes. That would not happen. That's not, that wouldn't happen. What are the guidelines for aesthetically pleasing from the perspective of the ACC? The ACC, my recollection is that it's intended to maintain the continuity of the appearance of the community. It is fairly broad, that part is accurate, but there is a reference there about maintaining the appearance of the community, which it's in the first part of the ACC. How are things that have a grandfather clause in an ACC approval going to be taken? I assume what you're meaning is if things are previously approved by the ACC, can the ACC subsequently change their mind on something? If you have a valid ACC approval,
The
I would not
ACC request form says right on there that if it's found to, at any time, that if the approval is in violation of the bylaws, the approval is rescinded automatically. So let's say they submitted a request to put up a gazebo, and it was approved by the ACC, and then several years later, they found out that actually the gazebo's on common area. States right on there, we can give you a copy, it states right there that even if it's approved, if it's in violation of the bylaws, it does not stand.
So that would be an instance where there'd be a violation of the bylaws that would require it to be removed because, all right, uncommon element. Guidelines on fines. There are two provisions on this at the back of the bylaws. There's a provision regarding the remedies on default, and then there's a separate provision regarding fines. The goal of these is to provide notice of fines, so you know in advance what fines would be. It's a staggered sequence. It starts at 0. I think it goes 0, 50, 100, 250. And then for the fourth and everyone on, it's 250 after that. As far as you have a question about your fence, I can't weigh in on that one. I don't know. And artificial flowers. I do believe in landscaping that artificial flowers are permitted with board approval, if I remember correctly, under the new ones. Under the new ones. So that's it on my end. Thank you very much for coming out, especially those that stayed. And just so everybody knows, differences of opinion are totally fine and expected and a good part of the process. So that's just the way it goes. Whatever your vote is, I would encourage you to submit it, get it in on time. July 20th is the date. If you can't get your vote in by the time of the meeting, make sure you get it in. Or if you can't attend the meeting, make sure you get your vote in. Thank you very much.
One other quick thing that I think we might have mentioned it in passing, but we had a group of individuals that really were the impetus for creating these new bylaws, and that's the bylaw committee. We had a total of like 6 or 7 people that worked for 2 years doing this. And believe me, it was pretty tedious. They went through the old bylaws word by word, sentence by sentence, even punctuation marks, okay? And I don't know if you can realize how mind-numbing that was. So this was not something that was done lightly. It was a lot of time taken to do this. And I'd just like to mention some names here. George Moran, I'm sorry. Kathy and Dave Bentz were part of the committee. Mike McGee in the back with the hat on. Mimi McDonald was involved with it. Jackie Gunterman was involved with it. So a big thank you to all of those people for the time. And again, these are all homeowners, they're all volunteers. your efforts really are appreciated, and I just hope that the homeowners understand and realize what was involved with this. Again, 2 years to do this, it was mind-numbing at times, because I sat in on a lot of the meetings, and I don't know how they did it, to be honest with you, but they did, and they got through the whole thing. If you do have further questions, if you come up with something that you're not sure about, please let the office know. Come to our meeting. We'll be happy to answer them for you. We want it to be as transparent as possible on this. We don't want to hide anything from anyone. We want you to be comfortable with it. We want you to understand it. And if you've got questions, ask us. We'll be more than happy to answer them for you.